Hey, good afternoon, everyone. We're going to get started here in just a few minutes as we wait for everybody to trickle into the Zoom webinar. Okay, it looks like the participant list isn't going up anymore, so we can go ahead and get started then. My name's Josh Fuller. I'm a member of the DAYL CLE committee, and I'm happy to present Brent Hockaday, a colleague of mine at Bell Nunnally here today. He's going to be telling us a little bit more about the evolving landscape of non-compete agreements and the proposed FTC regulations in connection with that. Brent did a great presentation, same presentation a couple months ago to the DBA uh, employment law section, labor and employment law section. I was in attendance for that. I got a lot from it. I hope you all similarly find this presentation useful. So we will go ahead and get started. Brent,
Excellent.
floor is yours.
Excellent. Thank you, Josh. And thank you, everybody. I appreciate you spending your lunch hour with me and Josh. And I really enjoy, getting the opportunity to speak with people about this topic and just kind of the overall landscape of this area of the law that I think is, for those of you in private practice, I think will be helpful because it's not something that you learn about, especially when you're younger in law school, or you may not get as much exposure to in your early years. And for those who are in-house, I think it can be helpful for understanding, if you're wanting to pursue something, enforce something, or if you're on the back end of receiving something. So this is definitely an area that is fraught with gray and dispute. And despite some of the issues that we're going to talk about today, it's not going anywhere anytime soon. So a little bit before we get started, just a little bit of background about myself. I've been practicing law for about 12 years. I'm a partner here at Bell Nunnally. I do employment law, a little bit of commercial litigation as well. My area of practice includes restrictive covenants like non-competes, non-solicits, trade secret disputes, breaches of contract, as well as your standard wage and hour or single plaintiff lawsuits or class and collective action matters involving wage and hour. And for those of you who practice in this space, you know that Texas doesn't have class employment, but other states do. So that kind of gives you an idea of my background. What I want to talk to you guys today about is kind of these categories that I've laid out. First is the present state of the law. Before we get started and going where things are going or moving, I think it's important for us to understand where we are, what the law is, and what to expect with your existing agreements and those disputes that may come up in the near future. Then I want to talk a little bit about some of the movement that we've seen across the country. And I think this is important because it's indicative to the main entree, which is the FTC's proposed regulation and the dramatic effect that it could potentially have on employers and agreements across the country. This is especially important, I think, for those of you who may be in-house and have operations in different states. I often, whether it's clients of mine or people that I'm working with for the first time, if there's an existing agreement or apparatus in place that sets forth some of these restrictions, oftentimes what I see is kind of a shell or a form one size fits all, and that can get you into trouble in certain areas, which we'll talk to. And then we'll conclude with a little bit of key takeaways, as well as any questions you guys may have. And feel free to either at the end or afterwards email me or Josh, and happy to get going or happy to answer any of your questions. So first things first, what is a non-compete agreement? This is a term that is thrown out a lot by people that are in law, people that are in business, or just people that are employees of random companies because they've heard of it, they know of it. Oftentimes there's this assumption that non-competes are not enforceable or that they are enforceable. Here is kind of the parameters of the guidelines of what a non-compete is, what's required, and what makes it enforceable. The first is that it has to be part of or ancillary to another enforceable agreement. So what does this mean? It means effectively that you can't have just a pure non-compete. If you're signing a contract with someone, it can be titled non-compete agreement. Non-compete can be referenced throughout. It can even be robust in certain circumstances. However, it must be part of another agreement. Typically, you see it in two instances: an employment agreement, which I'll get to later, and then a non-disclosure agreement. The second thing is you need sufficient consideration. This differs across states because there's not a federal law that presently that sets forth the standard of non-compete. So each state is different. And in Texas, to have sufficient consideration, I listed out three of the areas that would cover it, not that fourth, which I said some states, Texas. The first is you need to give the employees access to confidential information or trade secrets. So certain information, especially those in whether it's in technology, financial services, insurance, manufacturing, real estate, there's different pieces of information that allows those businesses to succeed, or that have helped generate the goodwill in the marketplace and stature where those businesses are. In order for you to restrict movement or restrict activity from an employee who's leaving your employment after that employment ends, you need to be able to provide them something of value to perform their job. And confidential information and trade secrets is typically the most common. Now, oftentimes the interpretation or the argued interpretation of those definitions is much broader than they actually are. I've seen in many instances where people say something's confidential or a trade secret, and then you click on a link and it's on the internet. So we can talk a little bit about that as far as what you need in order to do that. But you need to give them that's one example of a consideration that would lead to an enforceable agreement, which is giving them access to that confidential information. Second is equity or ownership in a company. That's been argued up to the Supreme Court, and that's been found to be an enforceable, valid form of consideration. You often see that with startups. One of the incentives to join a startup, is to, in addition to whatever pay they're giving you, is also equity opportunity. So you'll see that there. And then the third one is specialized training. So specialized training, think certifications, CFAs, or CPAs, something specific to your industry, not Windows training or onboarding training, something basic. So that's where they are. And then some states, not Texas, allow for continued employment. And then the last piece, this is where all the fighting happens typically whenever there's a lawsuit, is that the terms have to be reasonable. And what that is it's necessary to protect a legitimate business interest of the company or goodwill. Those areas that we just talked about, the consideration, are those areas are standing in the marketplace. And the three areas in non-competes that they look to are time, geography, and scope of activity. The time, it can't be forever. The geography, it can't be anywhere except in certain circumstances with specialized workers or certain executives at large companies. And the scope of activity, most judges are reluctant to keep somebody out of work, especially for an extended period of time. In the case of non-solicitation, usually you don't see geography. It's more tethered to the clients who you would want to protect or the employees you want to protect. And I can talk, about that. Where I see a lot of employers go astray is when they try to get overbroad with that, and they think that any client that ever touched their company is theirs forever, and that's not always the case. There really has to be a connection with the worker and that particular client, or the worker and that employee, or the worker's ability to perform the services for the company and that employee, that client. Otherwise, the courts are going to be reluctant to enforce that. What they'll do is they'll actually reform it. So, as I mentioned, earlier, and I'll mention kind of throughout here, other states have similar requirements, but typically it's a different analysis state by state. So if you have an agreement for an employee that is in Texas, that may or may not be enforceable in Colorado or Minnesota or Michigan or Virginia. You really have to look at it on a state by state. However, there are certain things that you can do that most states are going to be okay with. I'll touch on that. But the takeaway is that no one size fits all. So what are the consequences if there's a violation and there's litigation? Well, If company A wants to go after an employee who left and they say that you're working for a competitor and you agree that you wouldn't work for a competitor for up to 1 year or 12 months after your employment within a 10-mile radius, and you're doing that, the court is going to evaluate those factors that we talked about. Is it enforceable, and are the terms reasonable? And this is where I think it's important for those of you who are on the drafting end of it to consider, where does my goodwill extend? If I'm a retailer, what's my customer base? Do I serve the whole country, or do I just serve the neighborhood or the city or the county? And oftentimes where companies and employers can misstep or overreach is when they extend their goodwill or their restriction beyond where their goodwill extends. So that kind of measuring, balancing act really needs to happen for drafting in. But say that that's done correctly, one of the options, a judge can enforce it as written. Okay, you entered the agreement, the terms are reasonable, I'm going to enforce it as written. And they may issue an injunction if it's an emergency proceeding or at the end of the lawsuit and say you can't do X for this amount of time, whether it's compete through working or selling to certain clients or soliciting employees to join you in your new endeavor. The second thing that they can do is they can just find it flat out unenforceable. It's not the ancillary to or part of test. You don't see that hardly anymore. I think most people are equipped well enough to understand it has to be part of another agreement. But there are occasions where I've seen that in my practice, not much, once or twice, but where it's a naked non-compete. It's literally that's the whole agreement. That's going to get tossed. Insufficient consideration. You said in your agreement that you were going to provide me confidential information and trade secrets, but my job was answering the phones, and I never saw any of that. So where's the give and take? And then of course the overbroad issue. What happens whenever an agreement is overbroad, the statute directs the courts to reform it, at least in Texas. So say I often see this when I'm representing a company who hired somebody and is brought into the lawsuit by the old company. So the way that scenario goes is old company has an employee who quits, goes to a competitor. Old company sues employee for violating their non-compete, and then maybe non-solicit too, and then they file a tortious interference claim with the new company. And oftentimes both sides are working together because they want to get past this. And one of the arguments that either the employee will make or if the company's brought in some way can make is that this is an overbroad non-compete, so judge, you need to enforce it. And it's not because I'm telling you or asking you, it's because the state or the statute mandates you do it. So what the court will do is say, I'm not going to give you no competition in the entire county, but I'll give you within 15 miles of where you perform the services, or 5 miles of where you perform the services, because that's where your goodwill extends. Or I'm not going to keep you from, not soliciting all clients of the company because this is a Fortune 10 company and pretty much everybody who lives in the state of Texas or the United States is a customer. However, I will limit you soliciting the customers who you perform the services for that company. And that's the key there. I think if you narrow and limit to those people who you sold to, or in the case of employees, you can hire, this is a multi-billion-dollar company with 50,000 or 100,000 employees. I'm not going to restrict you from soliciting all of them, but those who you worked with, like in your division, I will. So that's what happens. And what they call that is blue penciling is the phrase, but effectively think of it as redlining the non-compete agreement. The court will reform it. Now that's a significant measure because it does two things. One, it'll save a poorly written contract. However, the company that is pursuing loses the ability to obtain damages from any breach before reformation. So if you think about it, if I'm the old company in that hypothetical I just gave, I go after the new employee, my now former employee, and the employee says, hold on, this is overbroad. Court will say, all right, you're right, it's overbroad. I'm going to reform it, narrow it, and enjoin you from performing this activity as narrow. So now the only damages that I, as the pursuing company, can get are those that are obtained after. So if I breach it after that reformation, then I can get damages. Anything that happened before, you're not going to be able to recover from. And that often goes into the analysis of whether you want to pursue it. This is really geared more towards your in-house folks, and even outside counsel who's advising internal folks, because say you have somebody that that's going to work somewhere. It's different usually when you're stealing clients and business or information, but if it's just purely working somewhere, they're violating it. The question I always recommend you ask is it worth going after this person? Because the expense that you're going to incur is going to be significant. It is sometimes. Sometimes you have to have it. Sometimes maybe not. Or is the employee high enough that we really care? And those are the kind of conversations, of the practical real world conversations that you guys should be having amongst yourself before you decide to pursue. Because as those of you who have practiced in the space and worked on temporary injunction, once that starting gun goes off, it's anybody's guess how it winds up. So here, the big thing as far as emerging issues. Before the big entree, as I said, is the federal regulation pertaining to non-competes. But I want to talk a little bit briefly first about state trends we're seeing, and that's kind of what's led to where we are. I think it should be no surprise to no one that the great state of California does not enforce non-competes, and at least their case law as of the last 4 years doesn't enforce non-solicitation clauses either. So that's probably your least restrictive. Now they will enforce non-disclosure agreements. So if somebody steals information or trade secrets, confidential information, that'll be enforceable. But if your goal is to prohibit someone from working there or soliciting your business, I would think twice before you try to pursue that. The other one that is surprising is the state of Oklahoma. Everybody thinks of that as a more business-friendly conservative state. I think it is. But they do not enforce non-competes. Now they will enforce non-solicitations, and that's the same with Minnesota. Minnesota's was recent. It just enacted, and I believe the law was just passed that amended their statute in July of this year. So that's a newer one. But the trend that we're seeing is that there is a limit to the number of people and places where they're going to force it, where courts are willing or going to enforce non-competes. And I'll get into this when we talk about the federal regulation, but the idea is, from a macro standpoint, they want movement among the marketplace. And people who have done research on this believe that, it's been overdone to a degree that it's restricted that somewhat. So the other area that you're seeing is income limitations. And part of that market movement has, in their estimate or their study, has affected income of people and across on a macro scale. So states such as Illinois, Colorado, Oregon have passed legislation that amends their non-compete statutes and puts minimum thresholds. So if you make under $75,000, $85,000, $100,000 a year, you cannot be subject to a non-compete, even if it's the best written non-compete you have. So those are things to be mindful of when you have agreements that you're looking to roll out, or if you have legacy agreements from people 4 or 5 years ago that are still on the books, so to speak. Because a lot of these laws that have passed have been in that since that 2018, 2019 period, and as Minnesota just this year. So you may have agreements that are in effect, or advising clients who have agreements that are in effect that are really outdated. And the question that I get posed a lot is, well, even if it's not enforceable, I have the discretion, don't I, to go after the person? So does it really matter? And the answer to the first part of that is no, because you're right, you do have the discretion of whether you're going to enforce it or not. However, what I tell people is that where you really are going to run into trouble is when you have that one employee who walks out with $1 million book of business, or you have that one employee that takes the entire hard drive that has the entire database of the company and clients, or formulas that are needed to make whatever product that you have. And then you want to enforce it. And then there can be punitive pushback from a defendant that a defendant can apply to somebody pursuing enforcement that is troubling. For instance, troubling to the party that's trying to enforce it. For instance, in Texas, if you as the employer knowingly try to enforce an overbroad non-compete, then you may be liable for the defendant's attorney's fees. They could have done everything in the wrong, but you may be liable for their attorney's fees because you knowingly tried to restrict their movement when you knew it was overbroad at the time that you entered the agreement. So those are things to be leery of and be cautious of advising or looking to enforce. The consequences of these, I think, are pretty apparent, but whenever you're increasing the income threshold or limiting who can be enforced, you have a diminished population of workforce who a non-compete agreement can bind. So this is really important for those of you who either advise or work for organizations that are across the country or in different states. It's really important to be mindful of where my agreement, what does it say, and where can I enforce it, and do I need to roll out a new one? And that kind of goes into the tenuous enforceability of pre-existing. So what my guidance typically is let's have a more targeted, strategic, and selective approach as to who we want to enforce this on, or who we want to be bound by it. Oftentimes, I think anybody, whether they're an hourly employee all the way up, should be subject to non-disclosure agreements if they're going to have access to confidential information and trade secrets. But as a billing coordinator, do they need to be subject to a client non-solicitation and they don't interact with clients? Or is somebody who works in an administrative capacity that doesn't see clients need to? If that person were to work for your competitor, so long as they didn't take your information, would it harm you in any way? Those are the questions that you want to ask on the front end. So whenever something does happen, you have a plan in place. All right, so here is the big one. Now, for those of you who practice in this space or read what I'm sure are the 5 or 6 Texas lawyer related publications in your inbox, this is not news to you. You've known about the FTC's proposed rule banning non-competes. And there's been some excellent presentations on this topic through Dallas Bar Association and many across the country. So I would encourage you, if you want a real deep dive in there, explore those as well. But what I want to talk to you a little bit about is kind of the history of the FTC's experience regarding non-competes and how we got here, and then a description of the proposed rule. And I think this will help you, both in-house counsel and outside counsel, with advising your client, whether the client is your CEO, your executives, or your connection to the company. So to help them understand why it is, they need to be aware of this, why it's important, and they should plan for it. So for those of you who don't know, the FTC is a federal agency with nationwide authority to regulate effectively unfair methods of competition. And these non-compete agreements, non-solicitation agreements fall under that umbrella. So they've always had regulatory authority, and they can bring administrative actions in federal court. I'll give you an example of a couple where they did. But oftentimes, especially those employment lawyers, and even some commercial litigators who deal in this space, you don't hear much about the FTC taking on these kind of cases. You hear that more in the antitrust realm, but these touch on antitrust issues. So they have the rulemaking authority to address unfair practices. And I put a link in here. I'm happy to share the slides with anybody who wants them afterwards. You can click on there. It's a nice little one-stop shop that explains the rulemaking process and then this rule in particular. So how do we get here? I have a timeline. I won't read it to you. You guys can look at it. But the big takeaway is about 5 years ago, and this predates the current administration. So as you all know, federal agencies are swing with the pendulum of elections, right? As far as who's running them and the priorities, the policies in place. So when one party's in office, typically there's one view of these, and when another party's in office, they have a different view of these. But if you look under here in 2018, when we had a different administration in the White House that had a different philosophy and belief as far on these agreements, there was a study that was done and hearings that were held also in the Congress as it related to non-competes and the effect that it had on workers in the economy generally. And the biggest takeaways were that they suppress wages because it keeps employees from moving different places to maximize their potential market value, and that they were overused. That was really what it is. There's the famous Jimmy John's case where it was a sandwich delivery person. They tried to enforce a non-compete on this person. I think he delivered by bike. So effectively, it was, okay, you guys have overreached for too long, so now there's pushback. And in 2021, after President Biden was elected, he issued an executive order. I did a presentation on this back in August of 2021 with the state bar, and he effectively directed the FTC to address this issue head on. And I don't know if I have this in the slides, but just so you know, and you understand that it's a bipartisan matter, there is, I believe it's still in committee. I don't think it's gone anywhere, but there is bipartisan legislation that is circulating to more or less mirror a lot of the restrictions that we're talking about. So it's definitely on the radar. The key takeaways, looks like close to a fifth of workers were covered by non-competes. I talked about the income suppression. This study estimated it at nearly 300 billion. And then what I thought was interesting was the cost of healthcare and how that went to the tune of 148 billion, which I thought was pretty shocking on there. But that gives you an idea of kind of how we got there. And then the two case examples that I told you about, there was Prudential Security, where there was a security company and they wanted to prohibit security guards from working within 100 miles for 2 years after their employment. I think, unfortunately, we don't have bullet trains like they do in Japan. That would require everybody to move to work. And, the FTC was really upset about that. And then there's also the OI Glass case, which you can read about. But it really, the takeaway here is when you get too aggressive with a workforce that really isn't going to cause you harm if they leave, tread lightly, because there could be consequences, and in this case from the federal government. And yeah, we can probably skip through here. This more than a takeaway. So the big deal is what does the rule propose, or what does the proposed rule actually do? So I mentioned this before. It's unfair method of competition. That's the focus here. But I highlighted and underlined the key phrases of the proposed rule that I think you should look at. Worker, maintaining with the worker, or represent to a worker that the worker is subject to. So what this means is that if this becomes a rule and there's not an injunction that's put in place that makes its way to the Supreme Court, that the rule would prohibit anybody who meets the definition of a worker, which I'll show you on the next slide or two, cannot have a non-compete, maintain a non-compete, or be represented to that they have a non-compete. So this goes to those existing ones that may have been signed when they onboarded 5-6 years earlier. And what it does is it prohibits a contractual term between the employer and the worker that prevents the worker from seeking or accepting employment with a person, so they wrote that pretty broad, or operating a business. So if you have an enterprising employee who thinks that they can go out on their own and do it better, they're going to, under the FTC's proposed rule, they're allowed to do that. Now, they can't take your information and do it. I'm going to talk about that here. Actually, I can talk about it at this bullet point, but in the next slide as well. One of the things that, actually, let's get Josh, we'll go back one when I want to talk about this. The big question, this was a big question that I had when I first saw the regulation, and this is a question that a lot of people who I spoke to, whether it was clients or just friends that operate or work in the space, had when this first came out. What is a non-compete? So a lot of people, even lawyers, call non-competes, non-solicits, even NDAs, it's a non-compete. They kind of throw it under that umbrella. But what the federal government is proposing here is that they do the exact same thing. And they created what they call a functional test. So it's determining whether a certain contract provision is a non-compete provision. So even if it doesn't say you can't work there, does it have the effect of preventing you from working there, that new place, wherever that is? And if so, then they're going to view that as a non-compete. The classic example would be your sales folks. If you have a sales team that, say operates in a region, and you enter into a non-solicitation agreement, not a non-compete, you tell them, hey, you can go work anywhere. You can go work wherever you want, but you just can't sell to a certain number of people or anybody in this region. well, if my profession is sales and that's all I've worked in for 20 years, you're effectively keeping me from pursuing my profession and I can't work. And I'm going to view that as a de facto or a backdoor non-compete. For those of you who are of a certain age and appreciate it, The Simpsons had a funny episode where they were spoofing a cult or something, and the line was, you can leave at any time, but when you try to leave, there's landmines, tripwire, and razor wire fences that prevent you from doing that. And that's a more dramatic kind of comparison to what it is the FTC is trying to address here. It's this idea that you're not going to be clever and draft your way around a non-compete if it has the effect of preventing the person from working. So that's something to be mindful of too. However, non-solicitations, NDAs, even under this proposed rules, still would be fair game. So in the key takeaways, I'll talk to you about how to draft that. And really, that's best practice for, even if this thing doesn't ever become law because it's enjoined, we'll say Congress, or they exceeded their authority by not going through Congress. I think the key takeaways are pretty similar. So who is a worker? As you see here, it's an employee, a volunteer, an apprentice. It's a pretty broad definition. I like to think of it as probably the corollary to the FLSA's definition of employer. It's broad. So that's who you should be aware of that. You guys can read the rule for yourself, but this kind of gives you a bullet list of who it is, and especially independent contractors. As a general rule, you shouldn't be having independent contractors that are performing work for you subject to non-competes, non-solicits perhaps, but not non-competes, because if you're in that independent contractor employee dynamic and you say, well, you're not subject to employment laws because you're an IC versus an employee, restricting their ability to work elsewhere is one of the big factors that's like that. So something to consider. All right, so the main elements of the proposed rule: prohibits non-competes for all workers. I love how it's delayed here. Explicitly defines non-compete to include those de facto ones I just talked about. And then here's the kicker: you have to notify your workforce and rescind any existing non-competes in effect. So if this does become the law of the land, then your agreements that you have would be, you have to notify them. And that could be problematic because I've dealt with clients who think, oh, well, they told me the agreement's no longer any good, so I can do whatever I want. Then they take all your information because it's been played in there. So I think the best solution to this, which I'll talk about later, is really taking a look at your current agreements now and seeing if they need adjustment before this comes out. I already kind of talked about what a de facto non-compete agreement is, but I think what you're going to find is if this law does become, or this rule does become the law of the land, that there's going to be a heightened scrutiny that's applied to these type of agreements. And if you're on the defending side, I think one of the first arguments you'll make is that if they're going after you for non-solicitation or even misappropriation of trade secrets, if in addition to it not being a trade secret, this has the effect of preventing me from working. You're saying I can't work anything, and as a result, it's an unlawful non-compete judge. You shouldn't issue your injunction. You should throw this out. So something to be aware of and prepare for. Now, here's some examples that we have of those items that would be considered de facto agreements or de facto non-compete agreements. The second bullet here I think is important. It talks about requiring repayment of training costs where the payment is not reasonably related to the cost. So the courts are already leery of that in different areas. You see that a lot in the wage and hour realm. Be very careful what you're requiring your employees to pay. The other issue too is which employees group are you going after? Is it one that's earning a lower hourly wage and they can be able to do it, or is it more executive ones? Is it if it's reimbursement for education, certification, things like that, that is usually going to be fine. But if it's something more mundane or not as intensive, something to be mindful of or consider. And then the disproportionately high liquidated damages provision, those you should be leery of anyway, just under basic contract law. But if the liquidated damages dwarf what the actual damages are, then it's likely going to be viewed as a penalty and not enforceable. So something to consider. Rescission requirements. So we talked about this, the notice. You have to notify your current and former employees. I thought it was interesting. It cannot be a mass communication. So what they want is they want something targeted. So it doesn't go in your inbox and die there, or you forget about it. They want it to be directed to the employee, and so the employee has knowledge and knows where they are. So that's something we're mindful of. The other thing too is that if this rule does become, there should be some administrative guidance that rolls out as well that kind of helps employers with this, but that's getting the cart before the horse. And here's an example of the sample notice, which I pulled from the FTC's website, which you can see for yourself. And nobody needs to issue this now, but just so you see kind of the level of detail and what it goes into for that. So where would non-competes apply? They would apply still to the sale of the business if you owned at least a quarter of the business. So one of the things that the federal government appears to have taken into consideration is this idea of a founder selling his business to someone, making a ton of money, and then putting up a pop-up shop that does the exact same thing across the street. So they are going to allow you for business sales. So think of those people in partnerships, LLCs, the health realm. It's a significant shareholder, corporation realm. In those areas, as part of the sale of the business, you can contract into a non-compete. That's going to be subject to different set of rules. Although you don't see those as often because obviously there are more employees than our business owners, but just to know that it won't completely wipe them off. So here's kind of where we are so far. And I think the big question a lot of you are going to have is how quickly is this going to roll out? And the answer is not soon. I did presentation similar to this that Josh mentioned earlier, and I also did another one with a gentleman who works at the FTC. And his takeaway was it's not happening this year and it may not happen next year because there's so many comments that they're having to go through. I don't know if, for those of you who don't know, it's a pretty cumbersome process when you're issuing a federal rule. There's a comment period, and then people submit comments to that. And I want to say there were more than 20,000 comments that were submitted. The usual suspects, as you can imagine, business and trade organizations obviously had a lot to say about this. So this is something that they're not taking lightly and that they're going through in detail. So it's not going to happen soon. And then when they do issue a final rule, a lot of people are speculating that certain organizations will file emergency injunctions to put a pause on it. A lot of you may have seen that with when the FLSA, or excuse me, the Department of Labor issued their rule on increasing the salary basis in 2018, I want to say 2018 or 2019. There was it was 2017. Either way, there's been a movement, but between the current movement where it was, there was an injunction put in place, and I believe the Supreme Court held ultimately that they exceeded their rulemaking authority, so that it never came into effect. So some people are speculating that. However, if you look at the legislation that's pending right now, you're going to see that a lot of these concepts and principles are being talked about through Congress. And if that passes there, it likely has a stronger case for survival. So, and we kind of talked about this 60 days after publication. So say it came out tomorrow, you would not need to immediately do anything. However, you would need to immediately start planning. They are going to allow you it's like about a 6-month period to comply with the rules. So there is some lag time. This will be helpful for large organizations that obviously have workforces across the country in different jurisdictions, and logistically it's just hard to move at the speed of light when you're of that size. So one of the things that I think that you guys would be well served to do in the interim, though, is talk about what the consequences are going to be from this. So whether it's your clients or the executive team that you work with, for those of you in-house, they understand what's on the horizon and they can prepare for it, or at least be ready for it if when it comes. Obviously, the business consequences, that's huge. In organizations where a lot of the revenue is driven by individual salespeople who have books of business, you see this in financial services, insurance, and the like. This could be consequential. So it's going to be really important in those industries that you really make sure you have a restrictive covenant if you're going to do one that's narrowly tailored on that non-solicit, and doesn't prevent the person from working under this regime. The compliance stuff we talked about, there's going to be notice requirements, and really your HR folks or your administrators who equipping them with the knowledge of what they would need to do in order to roll that out. And then, of course, the legal consequences. One of the things, too, that I didn't mention earlier is that this would allow certain state attorneys general to bring enforcement actions for violations. So if the FTC doesn't take it on, you still have the risk of the state attorney general. And if it's an election year, or if it's a mandate, or if it's a really strong focus by an administration in the state, you can bet that they will keep a close eye on agreements, and that may be an area of interest for them. So it's really important to kind of understand what the world could look like over the next year or so. So here are the key takeaways. I think this is probably the most important thing from that, because a lot of the information you can look up and research. But I think from a high level, careful planning and drafting, and then discretion with enforcement. So with careful planning and drafting, I think even if you already have existing agreements, I think it's not a bad idea to meet with either your attorneys or your leadership teams and say, okay, even if this doesn't become law, there is a trend and a movement across the country to limit the enforceability of these. And I don't want to be in a situation where we have a person who did really bad stuff and we need to go after them and not be able to do it, or have tenuous, outcome because we don't have a great agreement. So I think you need to really, sit down and plan who you want to include, who do you want to exclude. It's not an exact science, and it's not the law in Texas, but income is a big thing to look at. People making under a certain amount, do they really need to be subject to a non-compete? Can we just do an NDA? Does that mean that? Is it necessary and protectable? Is it a real protectable interest? And then the biggest one is discretion with enforcement. How have you been harmed? If you can't articulate how you've been harmed, it's going to be difficult to explain to a judge why the judge should keep the person out of work or keep them from pursuing their profession. So it's really important for you to understand before you go to the mat, because once the wheel gets going, it's hard to stop that thing. How is it you've been harmed? And I've been on both sides of these fights, and I can tell you that judges don't look too kindly when they're sold a bill of goods on the front end, and then when the evidence comes out, it doesn't show really any harm or that they've done anything. They're not so inclined to have the vigor that your client may. So it's really important to kind of understand that when you're looking at enforcing these and how you want to go about doing it. And then, of course, the biggest one is, what's the overarching goal here? Yeah. Is it we have to stop the bleeding? Is it we want to make sure that people aren't walking away with our information and we just can't have this? This is our standard. Having those conversations, I think, is going to be really important and understanding. So, and I think that's it. And then this is my colleague Jay Wallace. We did one of these presentations together, so I told him I would keep him on the slide, so he would get his smile, his picture in front of you guys. So that's all I have from a substance standpoint. I'm happy to answer any questions. I don't know if you guys are able, if you want to put it in the chat, or I don't know if I can see hand raises, but let me know. And if not, we can feel free to email me, and I'm happy to chat offline and answer any questions you have.
I've got the Q&A box open now, and it doesn't look like we've got questions from anyone. But please also be sure to check the chat box, because Sherry has shared the CLE course number for today for you to claim your 1 hour of CLE credit. So that's always important. But seeing that we have no questions for Brent, I guess we'll conclude today's presentation. Brent, thank you so much for devoting about an hour of your day to helping our membership out. I know you're a busy guy, and it means a lot to our members that we have lawyers in the community who are able to take time out of their day and share a little bit of their expertise with us. I hope everybody who attended here today found this useful and beneficial for their practice. And the CLE committee looks forward to keep rolling into the end of 2023 and into 2024 with other great presentations. So thanks, everybody. Thank you, Brent.
Thank you, everybody. Take care.